Thank you very much. Hvala vam najljepše, kolega Đurković. Lijepo vas sve pozdravljam. Evo, prvi dio će biti na engleskom, kasnije ćemo moći govoriti na srpskom, odnosno hrvatskom, da bit će nam lakše za diskusiju. Moram istaknuti na početku ovu rečenicu, to je takav protokol, da je ovo istraživanje, odnosno ova prezentacija provedena within the framework of the Central European Professors Network coordinated by the Ferenc Mádl Institute of Comparative Law, and Professor Gordana Kovaček-Stanić and me are honored to be members of this Central European Professors Network that has tasked to research how to protect family and family values in legal systems. My today topic is legal regulation of same-sex partnership in Croatia, and I'm supposed to talk about 30, maybe a little bit more, something more minutes. And I would like to have a look in our history. The first act that regulated same-sex unions was the Act on Same-Sex Unions, enacted in 2003. Then we had the Anti-Discrimination Act, Zakon o zabrani diskriminacije, Zakon o suzbijanju diskriminacije, koji that in 2012 was changed. That is important. Then in 2013 we had the change of constitution of the Republic of Croatia. It was done by People's Initiative referendum in 2013. It was the first citizens referendum and third one in Croatia, as we don't have as many as Switzerland, for example. And we have a constitution norm, marriage provision. Marriage is a living union between a woman and a man. This provision introduced heterosexuality as a principle on the constitutional level. And then we got the Act on the same-sex partnership, Zakon o životnom partnerstvu osoba istog spola, in 2014, and you'll see what happened lately. First Act on the same-sex unions in 2003 had regulation similar to extramarital heterosexual unions. That means only legal effects between partners. That means maintenance and property relations. And it's rather interesting. It's not maybe so important for jurists, but I would like to emphasize that our family theory always cared how the terms are. We always made a difference between extramarital unions and same-sex unions. That means we didn't want to talk about heteroseksualne izvanbračne zajednice and homoseksualne izvanbračne zajednice. We insisted always on a different notion. That means same-sex unions, not same-sex or heterosexual extramarital unions. That's because we have extramarital union in our constitution, and we wanted to have always we academics difference in linguistic notion. But you'll see it didn't help a lot later. This Anti-Discrimination Act, Zakon o suzbijanju diskriminacije, in 2012 weakened the position of marriage because it added some limitations, and that was the beginning of that what will later happen. The Same-Sex Partnership Act was the answer on referendum. I was a part of the commission that drafted the act. There were members from NGOs, and they were very loud. They have also their advocates in academic circles. That means our colleague, especially of constitutional law from another faculty. In this commission also were representatives interesting of Ministry of Administration, not of Family, Ministry of Family. That was a political decision, at least to make a slight difference between Family Act and the Same-Sex Partnership Act. We began to draft the Same-Sex Partnership Act, and then we came to provisions that were regulating relationships between same-sex partner of a parent, of a biological parent of a child. And in that moment, I didn't want to take part in it, so I stepped out, and that was and a lot of public and media was very interested. Why? So I had I had the chance to talk a little bit about it, and the consequence was that I was on a homophobe list, nominee for homophobe of the year. I thought, in fact, that in our Family Act from 2014, we had enough instruments, legal instruments, to regulate relationship between partner of the biological parent of a child and the partners themselves from the point of the best interests of the child. And when you read Same-Sex Partnership Act, it comes from the point of the rights of adults, not from the point of the child. In fact, the government wanted to regulate same-sex partnership, at least as a part of the Family Act, but they also wanted to introduce homosexual marriage. We know how it is done, because when the act, the Family Act in 2014 was enacted, they made equal extramarital union completely as a marriage. So any difference was pronounced to be a discrimination. And that was in the last parliament session, when there was a day only for voting. So no public discussion was available. And that was the way how you can, through a certain blitzkrieg, change the Family Act, how they did it. So it was also possible with homosexual unions, as well, as we had a similar experience. And here is a speech of Minister Arsen Bauk in Budva, that they intended, in fact, to regulate same-sex partnership among provisions of the Family Act. So the same-sex partners in their special act got anyway all rights and duties as they are married. And as our colleague, Professor Sanja Barć from Rijeka told, only the word marriage remained protected by a referendum. And that is one of reasons why a constitutional challenge, why this act is constitutionally challenged, and we are waiting for the decision of the Constitutional Court. The Act on Same-Sex Partnership provides two forms of partnerships. One is formal, and one is and the other is informal. This formal is registered. It is very similar to marriage, as it is concluded in front of a competent body, that is register, public register. And it is interesting, not only Croatian citizens, but anyone can conclude same-sex partnership in Croatia. And from the international private law point of view, only provisions of Croatian law are relevant for it. So I somewhere read that the first registered partnership was concluded between Croatian citizens and Serbian citizens. So that was one thing that connected two states. And informal same-sex partnership is a family life relationship between two persons of the same sex who have not concluded a same-sex partnership before a competent body, provided the relationship has lasted no less than 3 years and from its beginning has met the requirements prescribed for the validity of a same-sex partnership. So some prerequisitions have to be made, but talking about effects, they're completely the same as registered partnership. And the proof of existence of informal same-sex partnership is same as for extramarital union. That means declarative judicial decision. And if it is required for some purposes and for some other, it depends on the required effects. That's why we in Croatia have a crazy situation that for that extramarital spouses have same legal effects as marital spouses. But the proof, if the extramarital union exists, is differently regulated in different law branches. So this logic was also applied here. Different for pension, then is needed a judicial decision. Different for I can now remember, but inheritance and so on. And also this act forbids all forms of discrimination, whether direct or indirect, based on a concluded life partnership, sexual orientation and gender identity. And these all forms are prohibited. So this act has very, very strong legal clause. And if we have a look on the Anti-Discrimination Act, in this act, discrimination is not if someone is placed in a less favorable position when regulating the rights and obligations arising from family relations, when it is stipulated by law, particularly with the aim to protect the right and interest of children, and also which must be justified by a legitimate aim, protection of public morality, and favoring marriage. So this is completely different, and it's the question, of course, now we can argue about this in interpretation, what will be lex specialis or lex posterior, but you'll see trend is quite strong. Conclusion of the same-sex partnerships is in front of civil registrar. And there are register of same-sex partnership, same as civil registers of marriage, birth, or death. Register has no right to conscience objection. As far as I know, in France, against France was raised conscience objection as a right to freedom of conscience in front of the European Court, and the European Court declined this request. And here we can see the first register certificate number 1, It's anonymized, so you can see the names, of course, because it's also interesting, and because same-sex partners have the right to protection of privacy. But if you have a relation that is registered in public registers, it can only be protected in privacy, in the sense of privacy, as far as any other relation as marriage or anything, or something like that, anything else. They also have preconditions for the existence. It's a Croatian specificum, similar as for marriage, and it's not so important right now. But, and also what that means, they have to agree, same-sex partnership has to be concluded in front of register, and there should be two persons of the same sex, not like in France, two persons of any sex. And if this is not, if these requirements are not met, same-sex partnership does not exist. And they also have preconditions for the validity, at least 18 years of age. You can conclude marriage in Croatia with 16 if you have a judicial approval. Legal capacity, but a guardian can agree that someone concludes same-sex partnership. It's this new tendency also towards protection of the right of people who are incapable, and not blood relatives in a straight line, and inside conclusion up to sideline, concluded up to the 4th degree. Of course, there is no eugenic reason like for marriage spouses, but it's something like public order, public morale, and so on. And they are not allowed to be married or in a same-sex registered partnership. It's a principle of monogamy. Termination can be also similar as marriage by death, a declaration of death of a missing person, annulment, and break. And here the legislator used another term, not a divorce, because they wanted to make a difference to marriage by the court's decision on request of one or both partners. And here are the reasons when, and by a statement of agreement made before you register. But the act says if there are no minor children living in their union. And it's pretty interesting, at least, because it's enough if they have a child living in their union. And you'll see later that there are chances that they have legal relationship toward children. No, it's enough. There are minor children living in their union, and if you have a marriage divorce that is going to be divorced, then a stepfather, these spouses don't need to go to the court, and that courts have chance to decide on a relationship between stepfather or partner, extra-marital partner, and a child. So they're in a favorable position here, and difference. Here are legal effects of registered same-sex partnership, but same is as informal same-sex partnership. Personal, they have right to change surname. I don't know why it isn't so typical, because we know how the surname historically came to the point to be changed as a family common sign, how family participate in social life, and usually women change their surname, or completely, or only edit spouse's surname, and they have same rights and duties. Legal effects affect also property maintenance toward partners' children, but somehow different than heterosexual spouses or partners. They even have more rights than inheritance, tax exemptions, pension insurance, compulsory health insurance and health care, employment and employment relations, access to public and market services, for example, rental agreement, granting temporary residence for family reunion, free movement to the EU according to EU regulation, and also have right to asylum and subsidiary protection when they enter into the country, into the state. And for me, is the most questionable part, this part, considering children. Do they have right to become a parent? Not exactly a parent, because it would mean also another changes. In fact, they have no access to medically assisted procreation and adoption. But the second part will change. There is no ban in the same time for a homosexual person to adopt a child as a single parent. This homosexual person should not be in registered or informal partnership, but it's another one is difficult to prove. And woman who seeks medically assisted procreation can get it, but only for a health reason, not social infertility. So as far as I know, many of them use at least part of medically assisted procreation procedures, and then go, as I was told, to Macedonia. So they just take their eggs and freeze them, and let them frozen, and then ask the institution to transfer to Macedonia, and there get pregnant. And surrogate motherhood is not allowed in Croatia. Just also to say, we have also hetero. We have insemination and donor possibility of donor of eggs or semen or even embryo, but it is not in practice eligible, because there is no heterogen possibilities. There are some obstacles in practice to do it. And as in Croatia, a child has right to know the name of biological donor. People don't use this technique. Talking about relations connected to children, if one of partners have his or her biological child or adopted child, the partner of a partner has two possibilities. One is to exercise of parental responsibilities, and this is an institute that is in fact against the Family Act from 2015, because the Family Act from 2014, went aligned with the Same-Sex Partnership Act, has possibility that also other persons, not only parent, might exercise parental responsibilities, and it was changed in Family Act 2015 after the Family Act from 2014 has been suspended because it had so many controversial provisions and many legal holes. So now, on the base of the Same-Sex Partnership Act, partner may exercise parental responsibilities by court decision, or if he or she is entrusted by the parent who exercises parental responsibility, or by both parents, biological parents. So this partner may exercise parental responsibilities, together with parents or instead of its parents. If it is entrusted, so it's a way of, in a way, he's a trustee. He has or she has to fulfill the requirements for guardian prescribed by the Family Act. And this is based upon the will of a parent or parents who exercise parental responsibility. If it is longer than 30 days, this must be certified by a notary public. If exercise of parental responsibilities are granted by court decision, it's strange. The Act did not prescribe reasons for shared parental responsibilities. So in Croatia, we might have the situation that both biological parents and partner of one of parents, they all three together exercise parental responsibilities, we don't have this possibility in the Family Act. The Same-Sex Partnership Act invoked also the Family Act. So it's a cauchemar. It's such turbulence that I don't know how this would be applied. And even worse, according to the Family Act, it's not possible to have shared parental responsibilities against the will of one of parents. So they both have to agree. And here you have the provision that the court can grant exercise of shared parental responsibilities with no prescribed reasons and regardless of will of parents. So that's why I'm saying that's also from the view and from the standpoint of partners, children are not here taken into account seriously, although the Act has a provision on the best interests of the child. And the other possibility is so-called partner care. Somewhere I saw it's translated as partner guardianship. I like more this translation. It may be only by court decision, may be provided by a same partner care after the death of the partner, who is the parent of the child. And it can be granted by a court decision, but this partner also may apply to be adopter after the death of the parent, and then adoption is concluded by Center of Social Welfare. And the other possibility is that the partner can be granted by partner care, exceptionally during the life of the parent of the child, if the other parent is unknown or deprived of parental responsibilities due to abuse of the child. You can deprive a parent of parental responsibilities for so many reasons, and why they took here just abuse of the child also, I don't know. And you may see how sensible to partners' rights is Article 46.5. The court shall caution the Social Welfare Office that when drawing up its expert opinion, it must strictly respect the prohibition of discrimination on the basis of sexual orientation. That's how state trusts their organs or institutions like Social Welfare Office. It's a little bit funny for me. So everybody should obey legal provisions. Partner care is in fact adoptio minus plena. I remember this institute from my studying time. This partner guardian of the child shall acquire parental responsibilities and all the rights and obligations that derive from them. A note of the partner care shall be recorded in the child's birth certificate. So this partner is partner caregiver is guardian, is representative of the child, and the permanent rights and obligations which exist under the law between parents and children and their descendants shall be established. So it is always also possible to terminate partner care under certain conditions. Partners have also other rights and duties towards the children, parallel with the Family Act. Right to contacts after termination of partnership if a child lived in a family union. I didn't tell you it's called family union. That's very important for and family life. It's very important for later remarks. And also by the Family Act, the child has right to contact with emotionally close persons who lived with them in life union. They have right to make everyday decisions, and the child have right to get maintenance only in case of exercise of parental responsibility or partner care. On the other hand, stepfather should provide maintenance in according to certain provisions to a minor child, and also a child who acquired the age of majority should maintain stepfather or stepmother. Here this part is not provided. And that's legal regulation. This nice couple here is first homosexual couple who managed to change two laws. So this is the journal title. Media are very favorable, very favorable for them. These two gentlemen are highly educated, also have very high standard of living. One of them is molecular biologist, and the other one is a sociologist who is engaged in, as media say, in marketing. So they know how to approach to this problem. So they wanted two things: first, to become foster parents, and second one, to become adopters, to adopt the child. So we have the Foster Care Act from 2019, and we had a bitter discussion in Parliament and a ruling. And the government didn't want to accept that same-sex partners should have right to become foster parents. So we have these, they're out of scope of foster family, possible foster family. And on the other hand, if same-sex couple would need foster family as beneficiaries, they're not allowed to be placed together in a foster family as beneficiaries. So they challenged this provision in front of the Constitutional Court, and Constitutional Court ruled that they should have right to become foster parents without any argumentation about rights of the child and what would be in the best interest of the child. So here is the part of ruling of the Constitutional Court. If somebody is interested in, I can send it by my email. They also added that courts should interpret legislation in spirit of human rights. This was, I say, rather politically elegant, because just a year and a half before, Parliament, after a public discussion in Parliament, decided who should be considered as a foster family or possible foster parents, and then Constitutional Court corrects, not but judging that Foster Care Act is unconstitutional, but even more, it requires that courts should interpret legislature in spirit of human rights and conventions and constitution. So it is politically elegant, but also opens the debate on separation of powers of the state. And if you don't, especially if you don't argue, if you don't have arguments and also taking account rights of the child. So nowadays, the couple we saw is fostering a brother and a sister. I don't know if they are placed there out of family by the Family Act or by the Foster Care Act. And also, so that means, or by Social Care Act, it's a huge difference, because by the Social Care Act, a parent should agree to place a child by foster parents or in an institution for children. And by Family Act, it was the matter of discussion in Croatia if the decision where the child will be placed will be part of a judicial decision when the court takes a child out of family and according to measures for protection of child's personal rights and welfare at all. So they are now required not to go into media. So we don't know what's happening, what is happening later. By foster parents, the situation is completely different than talking about adoption, because we don't have foster families at how much we need them, because it's a process of the institutionalization of child institutions and homes. So it's a movement that mostly children should be placed into foster families, and there is not enough placement for children, even in children institutions. Also, there are not enough foster parents. So here there is in a way a sense why they might be somehow the way how to help children, but it's only a small step toward bigger goal, and I think the right goal of rainbow families. In fact, they are not allowed to adopt a child together according to the Family Act. A person who lives in a same-sex partnership also can't adopt a child alone as a single person. But the same couple challenged this provision and required from the social welfare office to go through the procedure to get the positive opinion that they are eligible to adopt a child, although it's not possible in the Family Act. So they challenged negative decision of the social welfare office and started the administrative procedure. And the first degree administrative court decided that they have right to go to this procedure. That doesn't mean that they necessarily should be adopters, but the administrative court ruled that they are discriminated if they have no access to get a license to adopt. And in fact, it's something completely different than in the Family Act. and also to make a difference between adoption and foster parenting. In adoption, we have in Croatia 6 couples waiting for a child, 6 heterosexual couples. So there's not enough children. And if you take also homosexual same-sex couples in this market, the question is what you are going to have. This judgment of administrative court is not final. I didn't have chance to read it, to read argumentation, but as far as I know, it's not so so strong. Otherwise, NGOs would make it public. I have also to say that media in favor to same-sex partners and also some courts. Last year we had a decision of the Zagreb Municipal Court, because one of the NGOs who protects family values had a campaign saying that the only appropriate family for the child is when a child is placed by the state is heterosexual family, and they were punished because of discrimination. And as a judge court, it provoked fear and to the same-sex oriented people and hate. So this NGO was punished by the municipal court of Zagreb. So it's a way of repression of talking in public if there are some other opinions. And to conclude, in 2015, from the Same-Sex Partnership Act, there were 100 concluded same-sex partnerships. We now have 50 to 66 partnerships concluded every year. Some of them even conclude to citizens, not national citizens. 7 years after legislation, same-sex partners are eligible to become foster parents and almost adopters. And Constitutional Court is waiting 7 years to decide on a constitutionality of the Same-Sex Partnership Act, although it is at least contrary to the Family Act 2015, and there also have some wrongfully shaped provisions from the point of legal system. I'm not talking about ideology right now, and I'm asking myself, is this price of being members of Council of Europe and European Union, or simple evolution of law? And just to add some sociological add to this discussion, Croatian society is still considered to be homophobic. So FRA, Agency of Fundamental Rights Agency of EU, still considers Croatia to be homophobic, but we have very modern, postmodern, I could say, legislation and jurisprudence. So I hope you understand my non-YouTube English. My son says, I can't hear you. How do you speak? His YouTube generation. But I think now we can discuss in Serbian and in Croatian too. Thank you for your attention. Hvala vam lijepa na pozornosti.